Okay, I'll admit it. I was watching the New Heights live stream when Taylor announced her new album. I'm not ashamed to admit it. But no, I wasn't there for the romance between Travis and Taylor. I was there for the copyright law. Because today, Taylor Swift stands in a position few artists ever reach. She owns her entire music catalog.
To put it in perspective, if I never would have been able to buy back my music, one day someone else would be leaving all of my music from my first 6 albums to their kids in their will.
Right. Yeah.
And you think about it like that, it's like, I thought of it, I made it, I recorded it, I paid for most of those music videos.
Taylor Swift dropped by her boyfriend's family podcast to talk about her new album and explain how she got the rights to the master recordings on her first 6 albums. And while Swifties can't get enough of the Taylor-Travis dynamic,
Says her boyfriend.
Smartest woman in the world.
I'll leave the relationship analysis to the gossip blog. Though I will say I did laugh when someone pointed out that this was like the scene from Beauty and the Beast where Belle teaches Beast how to read.
Well, here, why don't you read it to me?
All right. I can't.
But Taylor Swift's fight to regain control over her first 6 albums is a case study in how US copyright law treats sound recordings, venture capital's expansion into music rights, and why even a global superstar has to fight tooth and nail to control her own work. Now, if you've seen YouTubers suddenly take down videos where they analyze songs, it's usually because of copyright claims by companies who own the recordings. Even if they're breaking down lyrics or chord progressions, playing clips of the actual recording can trigger a takedown if they don't have the right licenses. Now, music tubers often have a fair use defense, but in general the rule is no license, no music, no video. But music licensing is also the heart of Taylor Swift's fight over her own masters. Whoever controls the music licensing has a lot of power. The power to put the songs in commercials, allow politicians to use them regardless of what the artist thinks about it, and to be jerks to music YouTubers if they feel like it. Seriously, Rick Beato faces copyright claims from companies who don't want him to play a clip of a song while he's interviewing the literal person who made the music, even when the person being interviewed said, "Please use my music." Luckily, Rick has a good lawyer. But why is this system like this? Because of the way that the Copyright Act and common law evolved to handle musical recordings. Now, we've talked about intellectual property many times on this channel, but here's a quick refresher. Intellectual property is distinct from real property. Real property refers to land and anything permanently attached to it, like land and buildings. Intellectual property refers to creations of the mind, which are intangible, like inventions, literary and artistic works, and symbols. Intellectual property rights in America come from Article 1, Section 8, Clause 8 of the Constitution, which says, quote, "The Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and the inventors the exclusive right to their respective writings and discoveries." And the IP clause is the foundation for federal protection of artistic works through copyright. Copyright covers many different kinds of works, including paintings, photographs, musical compositions, sound recordings, computer programs, books, poems, movies, architectural works, plays, and more, even YouTube videos. But generally, modern copyright law is governed by the Copyright Act of 1976, as amended under 17 U.S.C. 106. The owner of the copyright has certain exclusive rights to that work, including the right to reproduce or copy that work, adapt or prepare derivative works based on the original, distribute copies of it, perform or display it publicly, and perform a sound recording publicly by digital audio transmission. Now, for works created on or after January 1st, 1978, copyrights last for 70 years after the death of the individual author. Copyright law for musicians is especially complex because every recorded song has at least 2 separate rights attached to it, the composition and the master sound recording. Now, I'll let Taylor break that down for you.
So master recordings is the actual recording.
Yes.
It's the actual vocal, band, production, mixing, mastering, that actual thing.
Yes.
Mine also included my album artwork, my music videos, everything that went along with any era of music that I had done for my first 6 albums.
Got it.
Every era.
So then there's another category, which is publishing.
Yes.
I own my publishing, which is why, I have control over, if my song is used in a film, I wanted them to use Taylor's version instead of the original version, I, the songwriter, can decide that.
Now, the terminology she's using is a little inartful. I'll give her a break. She's not a copyright lawyer, but the sentiment is right on. The musical work copyright is usually known as a musical composition, which protects the underlying musical arrangement and accompanying lyrics of a song, whether the composition is fixed in written sheet music, recorded, or otherwise. The sound recording copyright protects the actual recording of the musical composition. And the Copyright Act defines phonorecords as material objects in which sounds are fixed by any method known or later developed. This means that the sound recording could be contained in a CD, in an MP3 file, or on a computer hard drive, or any other method that's ever invented. So you can think of the two musical copyrights this way. The music composition copyright is basically like the idea of the song. So if you transcribe the song into musical notation, you're kind of referencing the composition, whereas the master recording copyright refers to the way that the song was actually recorded on the day, the version that is usually the most popular version that was recorded in the studio. And it's confined to the actual sound recording. So imagine if you had a high school band that wanted to do a cover of a famous song. The teacher then starts handing out little sheets of paper with the music written down on it. They learn the song and then they play it. So that could be a violation of the composition copyright because they're not dealing with the actual recording on the album. They're just playing the music that was there in front of them, but they're recreating it using their own instruments. But now imagine you have a high school football game where they want to play a Taylor Swift song over the loudspeaker. They hook up a computer with Spotify attached to it and play that over the loudspeaker to the crowd. That's more of a violation of the master recording copyright because they are playing the actual song that was recorded on the album itself. But whether an artist can own their master recordings depends on how their contracts are written. Now, under some circumstances, the copyright does allow musical artists to reclaim copyrights they previously granted to others by filing a notice of termination within a specified time frame. But it's not unusual for artists to fight for years to regain the rights over their work, even after exercising their termination rights, because they have to follow certain formalities. For example, in May of 2025, Salt-N-Pepa filed a federal lawsuit in New York seeking to reclaim ownership of their early works under Section 203 of the Copyright Act. This provision allows artists to terminate copyright grants and regain their master recordings 35 years after the initial transfer, so long as they file termination notices. The duo submitted theirs in 2022, but Universal Music Group argued that the recordings were works made for hire and thus not eligible for termination rights. UMG also maintains that Salt-N-Pepa were not signatories to the original contracts in question, therefore they have no right to exercise the termination clause. Salt-N-Pepa also claimed that starting in May of 2024, UMG retaliated against them by removing their early catalog from streaming platforms, depriving them of royalties. John Waite and other artists tried to file a class action against UMG and Sony on the basis that the companies conspired to block musicians from reclaiming their copyright transfers using the 35-year rule, but Judge Lewis Kaplan denied the class cert petition because each artist case raised unique questions of fact, meaning that the musicians had to file individual lawsuits if their labels fight their termination requests. And that's just one example of how artists get screwed by the music industry. Most artists aren't even aware of their rights when they negotiate their first contracts. Because unfortunately, it's very easy not to read the fine print when you're engaging in contract negotiations with a major label. And not reading the fine print is often how a lot of your personal info ends up on the internet too. And it's not surprising because data brokers vacuum up all your personal data from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your personal data by signing up for today's sponsor, Incogni. Incogni removes your personal data from online data brokers by searching the internet, reaching out directly on your behalf, and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately or even had your identity stolen. Now, I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning that the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years. Now, I could never do this myself, so thank you to Incogni for saving me weeks worth of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you click on a link that's on screen or down below, you can try Incogni risk-free for 30 days with a 60% off discount and get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So sign up for Incogni or I'll see you in court. But as we explained in our first video about Taylor Swift, many musicians often sign lopsided deals when they're first starting out and don't have much leverage. If you signed a $100,000 deal with my fictitious label, Screaming Eagle Records, you'd be pretty excited. However, my company actually got the better end of the deal. The official finished sound recordings will be owned by the record company. This is the version of the song that is publicly released. These are generally called master recordings, and Screaming Eagle Records will not need your permission now or in the future to use these particular records or to sell them. How valuable are the masters? So valuable that everyone wants a piece of this pie. It's become a popular practice for producers and song engineers to demand a percentage of the masters for the work of their song. And sometimes this is an advantageous arrangement for musicians, but be careful because it will keep eating into your split anytime that recording is played somewhere else. Now, the publishing side of music is not as glamorous as music videos and records, but it can still be highly lucrative. Music publishers help leverage your songs to make money and protect your catalog of songs from infringement. And generally speaking, music publishers have two significant revenue streams. There are mechanical royalties and performance royalties. A music publisher can pitch your song to other artists who may record them, or they can get music plugged into advertisements, video games, movies, and the like. This might be financially lucrative, but it still means that as the musician, you're giving up another slice of the overall pie. But one of the really impressive things about Taylor Swift is that she writes or co-writes almost all of her songs, so she controls the composition side.
I've always been very lucky because my publishing was protected. A lot of artists have their publishing sold away from them.
Now, Taylor's position has always been that she wanted to keep the entire pie, but when she signed her first record deal at age 15, the label Big Machine retained the rights to the masters. In 2018, with her original contract set to expire, she tried to negotiate a 10-year deal that would have given her full rights to her master recordings and their visual elements. The Big Machine and its owner, Scott Borchetta, said no, so Swift signed a contract with Republic that gave her ownership of all future master recordings she made with the label. In 2019, Scooter Braun purchased Big Machine for $330 million, and that same year, Swift was named Artist of the Decade for the 6 albums that she made between the ages of 15 and 24, while signed to Big Machine. So Swift's music was the crown jewel in the Big Machine catalog, valued at $140 million, meaning that Swift was responsible for almost half of the company's value. But Braun and Swift were not friends, and she strongly objected to his acquisition of her work.
Since I was a teenager, I've been actively saving up money to buy my music back and to ever own it in the first place, because it's usually the label that owns it. But I've always wanted this to happen. So it's been sold. My music has been sold a few times. The first time that it was sold, it really ripped my heart out of my chest.
In a Tumblr post, she said, quote, "For years, I asked, pleaded for a chance to own my work. Instead, I was given an opportunity to sign back up to Big Machine Records and earn one album back at a time, one for every new one I turned in. I walked away because I knew once I signed that contract, Scooter Borchetta would sell the label, thereby selling me and my future." The Big Machine was not happy with her decision to sign with another label. Swift accused the company of retaliating against her by refusing to allow her to perform her songs on the American Music Awards and blocking her from using her recordings in the Netflix documentary about her life. Although the label has denied this, Taylor had receipts. An executive from Big Machine told Swift's representatives the company, quote, "will not agree to issue licenses for existing recordings or waivers of its re-recording restrictions in connection with the Netflix documentary." So here was Taylor's predicament. Even though she could perform her songs live, she couldn't stop the label from licensing her recordings to projects she didn't approve of or force them to let her use them on projects that she wanted. Swift kept trying to buy the recordings from Big Machine, but as a condition of negotiating, the company wanted her to sign an NDA prohibiting her from talking about Braun. Quote, "Scott Borchetta told my team that they'll allow me to use my music only if I do these things. If I agree to not re-record copycat versions of my songs next year," which is something I'm both legally allowed to do and looking forward to, and also told my team that I need to stop talking about him and Scooter Braun. So the parties were at an impasse. Swift would not agree to be muzzled, and Braun wouldn't sell without conditions. Braun complained that when Swift talked to her rabid fan base, she endangered his life and the lives of his employees. Hey guys, have you ever told a woman you need to calm down? If so, you know just how dangerous that can be.
There's just more to go to here. Sorry about that.
But later that year, Kelly Clarkson suggested that Taylor, quote, "just a thought, you should go in and re-record all the songs you don't own the masters on exactly how you did them, but put brand new art and some kind of incentive so fans will no longer buy the old versions. I'd buy all the new versions just to prove a point." But as Clarkson pointed out, musicians can sometimes re-record their songs, if they own the compositions, of course, because while some recording contracts include a re-recording restriction, often that expires after a set period, usually 5 to 7 years after the song's initial release or 2 years after the contract ends, and some contracts don't have a re-recording clause at all.
And also, in my contract, they didn't put a clause in that said I couldn't re-record.
So without that restriction, the artist can legally make new recordings of the same compositions they wrote. And that's exactly what Taylor Swift did next. She produced new versions of her first albums one at a time, including some fresh cover art and multiple bonus tracks on each record. And just as she hoped, fans started buying and streaming Taylor's versions instead of the original versions. And the recordings were a massive success.
And they're
And
like,
they-
Right away.
screw the first album. We're rolling with the re-recorded album because we're supporting the artist.
They were like, we ride at dawn.
And this threatened to slow down the appreciation of those original Big Machine records. So just 17 months after buying Big Machine, Scooter Braun struck while the iron was hot and sold the masters to a private investment fund for at least $300 million. But that did seem to accelerate the bad blood between Swift and her old label. She said, quote, "A few weeks ago, my team received a letter from a private equity company called Shamrock Holdings, letting us know they had bought 100% of my music, videos, and album art from Scooter Braun. This was the second time my music had been sold without my knowledge. The letter told me that they wanted to reach out before the sale to let me know, but the Scooter Braun had required that they make no contact with me or my team or the deal would be off." So it seems that Braun was able to cash in, almost doubling his money because of investment funds starting to buy up music rights. This was and still is a trend. Investors are shelling out 10 to 20 times what a given catalog earns in a year. Bob Dylan sold his entire catalog for $400 million. Bruce Springsteen sold 300 songs and 43 albums to Sony for $500 million. But not everyone who made influential music was able to cash in. In 2020, a firm purchased a 50% stake in Rick James' catalog, including both the publishing and recorded masters. The song Super Freak is one of the most sampled riffs in music and is probably worth tens of millions of dollars on its own and probably more. But when James died in 2003, he left an estate worth just $250,000. But on May 30th, 2025, Swift announced that she had purchased the masters of her first 6 albums, as well as the videos, concert films, art, photography, unreleased content, and other related materials, after Shamrock had offered her fairer terms. On New Heights, Swift explained how the sale went down.
After the Eras tour, I had a meeting with my team and we decided this might be a good time to approach the current owners of it.
And apparently, and I don't recommend this, instead of lawyers, she sent her brother and mother to negotiate.
They told them the whole story of all the times we've tried to buy it, all the times it's fallen through, all the times we had gotten plans together and figured out something we thought was going to work and it didn't at the last minute.
And Swift explained that Travis was playing video games when she told him she just got a whole lot richer.
And I was so happy you were there when that happened.
I mean, I was...
Because I could not stand.
Yeah, I mean, I started crying too. You know, I'm a
You
crier.
were weeping.
I'm just so happy for you because
Chelsea Way.
I've seen how you make music. I've seen how you make these videos. I've seen the effort and the focus and the strategy behind what just one album in Torture Poets Department and in Fortnite. And I was blown away that you had been doing this your entire life.
But Taylor also emphasized that the acquisition was not about money.
I'm in the business of human emotion. I would so much rather lead heart first in something like this, because for me, this is not, oh, I want to own this asset because of its returns, because of its, because of the dividends that I will receive over the years. I want it because this is my handwritten diary entries from my whole life. These are the songs I wrote about every phase of my life. This is my photography, my music videos, most of which I funded, my artwork, everything that I've ever done is in this catalog.
But the announcement that Swift had purchased her masters sent shockwaves through the music industry, and other musicians have applauded Swift.
I have so many new artists come up to me now and say, hey, I didn't even know this was a thing.
Yeah.
And when I went to go and negotiate for my record deal, I negotiated to have my masters revert back to me after a certain amount of years, or that I own them outright.
Though music companies eager to leverage their power over musicians often responded by revising contracts and restricting musicians from re-recording their music, often for as long as 10, 15, or even 30 years. Because while the two different copyrights exist, you can still assign or sell those rights by contract. Though Swift had more positive things to say about the investment firm Shamrock than about her record label and the music industry people associated with it. And Swift thanks Shamrock for doing the deal. Now, the parties didn't reveal how much Swift paid or how much Shamrock made, but the rumors are that they made about 20 to 30%. Probably not an astronomical sum given the context, though it helps that Taylor Swift was actively trying to destroy the value of her prior master recordings by re-recording everything herself. But if Taylor ever decides to sign with a new label, she'll want a really good lawyer to review her contract. Luckily, I know a guy. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? Or how do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first, instead of chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.